more minutes to prepare our judgment. We have reached a conclusion in this matter, and I'm going to be dealing with our brief reasons for the conclusion we have come to. And lest I don't say it again, we reserve the right to supplement these reasons should this be necessary. This is an application brought on an urgent basis for the review and setting aside of what is described as the failures, alternatively the refusal of the first respondent, the President, to suspend the second to the fourth respondents, as well as to institute inquiries into their fitness to hold office. The further relief sought is that this court should order the President to institute the inquiries against the second and fourth respondents, as well as to provisionally suspend them pending the finalization of the inquiries. The application arises from the following brief facts. On the 11th of October 2016, the second respondent convened a press conference wherein, amongst others, he announced that the current Minister of Finance, Mr. Pravin Gordhan, Mr. Viswanathan Ivan Pillay, and Mr. Oupa Magashule would be charged for fraud and theft. This led to media frenzy, and a lot is mentioned of the effect of the preferment of charges against the Minister of Finance, Mr. Gordhan, Mr. Pillay, and Mr. Magashule by the applicants. Needless to say, 20 days later, the charges were withdrawn by the second respondent, having reviewed the decision to bring the charges in the first place. On 1 November 2016, the applicants sent a letter to the President demanding that he provisionally suspend the second to the fourth respondents, and pending inquiries into their fitness to hold office, to institute inquiries that would inquire into their said fitness to hold office. The letter also demanded the resignation by the second to the fourth respondents so as not to harm the law enforcement institutions of this country any further. The President was called upon to confirm by 1600 hours on the 7th of November 2016 that he would so act. It was further mentioned in the letter sent to the Presidency that should the President fail to so act, the applicants would assume that he had decided not to suspend the second to the fourth respondents, as well as to initiate the inquiries into their fitness to hold office. The President responded on the 7th of November 2016, acknowledging receipt of the letter. The President also asked for time to properly investigate the matter and asked to be given until the 21st of November 2016. The current application was issued and served on 9 November 2016 and set down for hearing on 22 November 2016. That is, it was issued and issued and served 2 days after receipt of the response from the President. Furthermore, on the 14th of November 2016, the President issued notices to the second to the fourth respondents to make representations to him by the 28th of November 2016 why he should not suspend them pending the inquiries into their fitness to hold office. This is the brief factual matrix that, in our view, is determinative of the application before us. We had extensive and very helpful submissions by all counsel who appeared for the respective parties before us. For the most part, the submissions we had addressed the issue of agency and ripeness. And this was due to a directive issued by this court earlier that the court wanted to be satisfied up front whether the matter was properly before this court for urgent relief. Mr. Unterhalter, appearing for the applicants, argued the applicant's entitlement to the urgent relief foreshadowed in the notice of motion. This relief, in terms of the submissions we've had, was based on the clear demonstration of incompetence and unfitness of the second to the fourth respondents to continue to occupy their positions and exercise the powers vested in those positions. He argued that substantial redress was not possible in the normal course, that is, in bringing this matter in the normal course of the processes of this court. He further argued that this matter strikes at the heart of our constitutional democracy and that this court should grant the relief as the continued occupation and exercise of power by the second to the fourth respondents had serious ramifications for our constitutional democracy. He further submitted that the justification for the urgent relief sought was based on the fact that the second to the fourth respondents would continue to make countless decisions which were prone to have disastrous consequences for those implicated, as well as for the economy of this country, based on what the media reported was the result of the preferment of charges against the Minister of Finance. It must be mentioned that the applicant's case is largely reliant on media reports. The respondents, in summary, argued that the matter was not urgent, and furthermore that the matter was not ripe for hearing at this stage. We have considered these submissions and the papers, and our view is that the applicants' minds were made when they sent the letter to the President that the President had no option but to accede to their demand foreshadowed in that letter. Their minds were clearly closed to any other response other than one complying with their demand. Evidence of this state of mind is found in the speed within which the current application was launched. That is, within 2 days of receiving the President's letter requesting for time to consider the matter and his options. Our view is that the President's request for time under the circumstances was not unreasonable. We are also not persuaded that the choice of conduct of the President to request representations from the second to the fourth respondent was irrational and unlawful. In fact, to the contrary, this presents clear evidence that the President was considering the matter. And we have nothing on record that indicates that the President had refused to do anything in terms of the demand he received. Our view is that based on the President's response, it was ill-advised and certainly unreasonable for the applicants to rush and launch this application, brushing aside the request for more time from the President. We hold the strong view that urgent relief, and we are supported in this regard by ample judicial authority, that urgent relief is granted in special circumstances in matters where a proper case for such relief is made out. The case before us deals with very important constitutional issues, and that are in the public interest and in the public domain. The matter also involves one of the key constitutional institutions supporting our democracy. It is, in our view, not the type of matter, particularly the facts and the issues it raises, that can be properly dealt with within the exigencies of the urgent court, where there is no adequate opportunity for judges to reflect on the issues raised and to reach sound conclusions and judgments. In our view, insufficient grounds were proffered by the applicants crying out for urgent relief. Furthermore, the relief sought has the potential for this court to stray into the executive terrain, which could, if not properly considered, violate the separation of arms doctrine, and which would have the implication of the judiciary straying into the terrain of the executive. We should also guard as a court against creating precedents were based on insufficient grounds and inadequate foundation to encourage ordinary citizens to use the courts as a platform to dictate to the executive how it should do its work. There is more than ample judicial authority, as I've said, that deals with the type of matter that can justifiably be brought for urgent relief in the courts of law. This case is not one of them. For these brief reasons, and as I said, for which we reserve the right to supplement should this be necessary, there can be only one conclusion, and that is that this application is struck of the roll for lack of urgency, with costs, including the cost of two counsel, where applicable. This being the result, there is no longer any necessity for the applicants who filed to be admitted as an amicus, that is transformed SA, to be entertained. Thank you. Court adjourned.